Okay, this is Thomas Freed on the Liberty Works Radio Network. This is the Truth Attack Hour, and yes, that's right, folks. We're back with the Truth Attack. Okay, I want to get right back into finishing up with reading from the Supreme Court petition we're submitting, encouraging the court to step up and apply the decisions they already made just a year and a half ago and more. Apply those decisions, both concerning the income tax being an indirect tax, not a direct tax under the 16th Amendment, and concerning the fact that any enforcement of a direct tax can only be lawfully and constitutionally done by enforcing the tax against the several states. So, for the last few weeks, I've been reading from a petition to the Supreme Court addressing why it's necessary for the court to step up and deal with these issues that they've already settled. But for some reason, the lower courts don't want to follow and apply. Gee, I wonder what those reasons could be. So, we are the Liberty Works Radio Network. We do need the support of the members of the listening audience to keep the broadcast network operating. So we sure would appreciate it if you enjoy the information, the discussions, the revelations, the lectures, the guests, and the hosts on the other shows on the network. We would appreciate it if you could find your way over to the LibertyWorksRadioNetwork.com website. Get signed up as a monthly subscribing member, even if it's as little as $15, $20 a month. Every membership helps, and we do need your support to keep the broadcast network operating. So, LibertyWorksRadioNetwork.com to support the network. And if you want to get more fully informed and fully educated on the maladministration of the federal income tax by the IRS, the federal judges, and the DOJ, you find your way over to taxfreedom.com and start reading Get Educated. If you know anyone that needs help answering IRS correspondence or answering the Department of Justice in court in either civil or criminal cases, you want to go over to irszoom.com, where we have the documents that will assist you in exposing the fraud being perpetrated by the court. And that has been fully exposed by the Supreme Court in a case called Moore et al. v. United States, 602 U.S. 572, 2024, just almost 2 years ago at this point, where the court ruled in a manner that completely contradicts what the circuit courts, the IRS, and the DOJ have been arguing and doing for 60 years. And that is, they've been enforcing the income tax on American citizens, claiming it's a direct, non-apportioned, unlimited, new power to tax directly and without limitation created by the 16th Amendment, so that now anything you earn is subject to federal taxation, regardless of how it's made or where it's made, regardless of the fact that it's made outside of the constitutional authorities to tax the citizens legitimately, i.e. indirectly by impost, duty, and excise, and regardless of the fact that they're enforcing a direct tax against individual citizens instead of the several states required by the Constitution, as upheld by the Supreme Court a year and a half ago, and as originally ruled by the Supreme Court in 1916 in the very first cases addressing the constitutionality of the income tax as an indirect tax, not a direct tax, in both Bruce-Shaver versus Union Pacific and Stanton v. Baltic Mining in 1916. And irregardless of the fact or in violation of the fact that they reaffirmed those decisions concerning the tax being indirect and direct taxes being apportioned in Stewart Machine in 1937. So every single time the Supreme Court has spoken about it, they have declared the income tax to be an indirect tax, and that the limitations imposed by Article 1, Section 2, Clause 3, and Article 1, Section 9, Clause 4 on direct taxation are still in place, have never been removed, and that direct taxes must still be apportioned to the several states for payment. That means the federal government can never arrive on your doorstep demanding that you pay a tax that is allegedly direct. And that's exactly what they've been doing for 50 years. Actually, 75 years, since Glenshaw Glass in 1955, when they started enforcing things directly under the DOJ's and the IRS's liberal interpretation of that case in 1955 is Congress exercising a power to tax all accessions to wealth. All the case really did is deem treble damages earned by a corporation as subject to tax just like everything else the corporation earns. So they never said all accessions to wealth are being taxed by Congress. That was not part of the ruling or the holding, and of course would have been absurd. Where would that power come from? Without addressing a foundational authority to allegedly tax under the 16th Amendment directly and without apportionment. So in Glenshaw Glass, that's inferred, but never laid out. And from it, the Justice Department takes all accessions to wealth are subject to tax. So now they're taxing directly, and they have to make up the authority to do it. That's the 16th Amendment. Oh, but look, there's no liability in statute for a direct tax. The only liability in statute is the liability of the tax collector, the withholding agent, to pay into the Treasury the tax he has collected from the foreign persons he's authorized to collect the tax. That's it. There is no other liability because there is no other imposition of the tax. There is only the duty to retain and pay the sum of the tax, collection of the tax at the source. It's not paid by the wage earner, it's paid by the collector, the same way that a sales tax isn't paid by the customer to the Treasury. It's paid by the store, the tax collector. You have the same indirect scheme. And because the collector never pays tax out of their own pocket, they only turn over what they have withheld, collected from other persons. It's an indirect scheme. And if they don't want to be a tax collector, don't do business with a foreign person where you're required to deduct and withhold. So since there is no liability in statute for anything except this indirect collection of the tax at the source, which the Supreme Court recognized and pointed out on page 21 of the Brashaber decision. I point out it's an indirect tax collected at the source, and that's what we find in the statute, liability for the tax collector, 1461. What we don't find is any liability under Section 1 for the tax imposed on taxable income. Is your name taxable income? How would you be liable for a tax on taxable income? It's not a tax on the person, it's not a direct tax. They made that up. And in order to support what they made up liability for it under a regulation and Chevron's regulatory deference, where the courts had to accept the IRS's interpretation in regulation of the tax imposed under Section 1. But the statute doesn't specify any liability for tax. It doesn't specify how it will be collected. It doesn't specify how it will be paid. It only says there's a tax on taxable income of different groups of people, married individual, heads of household. There's no liability in the statute. That would be direct taxation, unconstitutional. It's not direct, it's indirect. The liability is in the name of the collector. In order to make up the liability for the direct tax they made up under Section 1, which they made up under the 16th Amendment, they put the liability in the regulations for Section 1. But Chevron has been overturned by Loper Bright. There is no longer the ability to argue liability under regulation without a foundation in the statute that the regulation is implementing, because you can't write law out of a regulation. The regulations put in place by the agencies implement the laws made by Congress. They don't expand them, they don't enlarge them. This is the crime that has been committed at the agency level across the board for 50 years, using Chevron to defend it. Oh, the regulations, regulatory deference. Before Chevron, the courts had held you can't do anything in a regulation that isn't in the statute. For some reason, the court reversed that position in Chevron and said, oh, what the agencies make up in regulation, you have to accept. And the agencies went wild, writing their own laws to invade every aspect of our society. EPA, OSHA, HHS, the IRS, they're all doing it to invade the exclusive territorial and legislative prerogatives and jurisdiction of the state governments. And they corrupt the state governments with bribery and extortion. Oh, here's $10 billion for education, but only if you adopt Common Core and teach critical race theory, gender dysmorphia, feminism, etc., etc., etc. No reading, writing, arithmetic. Just teach the liberal agenda. Riot, anarchy, anti-American, rewrite history. Everything about you is bad. You should be ashamed of yourself. And of course, the kids are being indoctrinated with this nonsensical, idiotic propaganda that is rewriting history to get them to rebel as useful idiots for the Socialist Party. Okay, so I guess I'm getting a little bit off topic here, aren't we? We're gonna begin with the second break here, reading from the Supreme Court petition to address asking the court to please step up and apply these decisions that the income tax is an indirect tax of the form impost, duty, and excise. Imposts tax foreign persons, foreign imports, foreign labor, and in foreign places, territories, possessions, foreign countries under tax treaty. Duties tax exported goods. Neither imposts or duties can apply to the domestic labor of a citizen in the 50 states. They have to do with foreign activity, import, export, foreign persons in America, and all persons in foreign places. That leaves only excise. Excise taxes the manufacture, consumption, and sale of commodities within the country, licenses to pursue certain occupations, and the corporate privilege. Neither impost, duty, or excise taxes the labor of the American people or the rent, interest, dividends, alimony, compensation, or anything else acquired by right within the state without touching the federal jurisdiction of impost, duty, and excise, interstate commerce, or territorial jurisdictions. The whole thing is a fraud. The Supreme Court has exposed it. They said the income tax is indirect taxation. That's impost, duty, and excise. They specifically said under Article 1, Section 8. That's all there is impost, duty, and excise. The 16th Amendment doesn't create a new power to tax, again, directly from the Supreme Court. It permanently classifies the income tax as the indirect tax that taxes corporate income and foreign income. It's an excise on corporations from 1909. It's an impost on persons in the 50 states, foreign persons, under the original income tax legislation of 1913, the Underwood-Simmons Tariff Act of October 3rd, 1913. A tariff is one form of an impost which taxes foreign activity, which is why the tax under the law and the original legislation is only collected from foreign persons. Those are the only parties the federal government is authorized to tax outside of the territories and possessions. Okay, I think I hear the first break coming up. We'll be back in 5 minutes, and I am going to get to that petition here We'll see you then. We'll be back in 5. This is Thomas Freed on the Liberty Works Radio Network. Find your way over to the website and get signed up. Okay, this is Thomas Freed on the Liberty Works Radio Network. This is the Truth Attack Hour. And against that background that I laid out in the first 15 minutes, where I laid out the Supreme Court has already ruled the income tax is an indirect tax, not a direct tax. And that if it's enforced as a direct tax, it has to be apportioned to the several states, which they've been violating the Constitution for 60 years. The entire tax is a complete and total constitutional fraud. The Supreme Court has exposed it. And now they need to apply these rulings to a domestic tax case, the same way that they used them as the constitutional foundation to settle the foreign tax case that they came out of in Moore, which upheld the power to tax unrealized gains of an Indian company under the tax treaty between India and the United States. Okay, so here we go. Let's get back into it. I am going to just jump right into the petition to the court. I'm going to reread a couple of paragraphs just so that we have some continuity through the whole thing. Section 4, the direct tax error infected every stage of the trial: prosecution, sentencing, restitution, and collection. A, the first element of 7201 was never constitutionally established. IRC Section 7201 requires a tax due and owing as its first element. Spies 317 U.S. at 496. That element requires a valid constitutional tax obligation, an indirect tax, as impost, duty, or excise, on realized gain from a specific federally taxable activity or transaction conducted by the alleged taxpayer. The government never identified for any year charged the specific federally taxable activities or transactions allegedly conducted by the defendant, giving rise to any indirect tax obligation in his name. It relied on the direct tax theory that all income from all sources is directly taxable without limitation, as declared in Collins and the other circuit precedents. Under Moore, that theory is constitutionally erroneous and incorrect. The first element of Section 7201 was never constitutionally established. On this record. B, the restitution order is the direct tax error made concrete. The United States is not a statutory person eligible to receive restitution. Now, this is what they're doing to people all over the country. The restitution order is constitutionally infirm on two independent grounds. First, every dollar alleged owed was calculated under the erroneous direct tax methodology. The amounts from IRS assessments treating all income as directly taxable under the 16th Amendment. The amounts were calculated from a gross income formula that by design identifies no specific federally taxable activity or transaction subject to tax, but merely assumes subjectivity to direct tax on all earnings, as well as the assumed liability for tax, which also does not exist in statute. A restitution order calculated entirely on a constitutionally erroneous taxing theory of an unlimited, non-apportioned direct tax on individuals or their income, for which no liability is specified in statute that applies, is itself both constitutionally infirm and violative of law. Second, the United States is not a statutorily defined person eligible to receive restitution as a quote-unquote victim under any Title 18 statute, including sections 3556, 3663, 3663A, and 3563B2, etc., i.e., the restitution statutes. The long-established canon of statutory construction holds that the term person in a federal statute does not include the United States, absent a clear congressional expression specifically including it, which does not exist in the restitution statutes. United States v. Cooper Corps, 312 U.S. 600, 1941. Congress has not expressed an intention in the restitution statutes to include the United States as a person in Title 18 who can be a victim, nor in the restitution statutes, nor in the Title 26 statutes is the United States designated as a person. The Department of Justice's own guidance from the DOJ Criminal Resource Manual, Section 1048, acknowledges that governmental units themselves are excluded from the statutory definition of a person under Title 18, and by omission from the restitution statutes as well. They further acknowledge that some financial losses are not eligible for restitution, such as state or federal taxes, interest, penalties, or fines. A restitution order payable to the IRS for federal income tax fatally lacks statutory foundation under the Cooper Core Canon, which excludes the United States as a person who can be a victim eligible for restitution. Additionally, even accepting the direct tax premise arguendo, a non-apportioned direct tax on income cannot be constitutionally enforced against an individual under Article 1, Section 2, Clause 3, and Article 1, Section 9, Clause 4, as Moore confirms in its reaffirmation of said constitutional limitations, i.e., all direct taxes must be apportioned among the several states in proportion to their population under the last census. A restitution obligation premised on a direct tax that the Constitution requires to be assessed and enforced only against the several states cannot lawfully be enforced against an individual defendant. C, the $10,000 fine extends the direct taxation theory error. At sentencing, the district court imposed a $10,000 fine on defendant that further perpetuates the direct tax error independently of the criminal judgment. A chain of instruments, each link of which derives from the unconstitutional direct tax error, cannot impose fines or other collection instruments based on an ungranted and thus unenforceable taxing power, i.e., a non-apportioned direct tax. A fatal constitutional defect in the underlying taxing theory is a constitutional defect in every instrument derived from it, and is thus fruit of the poisonous tree, as the non-apportioned direct taxation of individual persons is constitutionally prohibited, more supra. 5, the conviction on all derived instruments are void for lack of constitutional subject matter jurisdiction. A court lacking subject matter jurisdiction cannot proceed in the action to try, convict, sentence, fine, render judgment, or order restitution, lacking that required subject matter jurisdiction to act at all in the case. This court has consistently held, quote, without jurisdiction, the court cannot proceed at all in any cause. Jurisdiction is power to declare the law, and when it ceases to exist, the only function remaining to the court is that of announcing the fact and dismissing the cause. Ex parte McCardle, 1869. Quote, the requirement that jurisdiction be established as a threshold matter springs from the nature and limits of the judicial power of the United States and is inflexible and without exception. Close quote. Mansfield, C. and LMR Company v. Swan, 1884. Quote, for a court to pronounce upon the constitutionality of a state or federal law when it has no jurisdiction to do so is by very definition for a court to act ultra vires. Steel Company v. Citizens for a Better Environment, 1998. The criminal prosecution of the defendant petitioner was expressly premised on an unconstitutional direct tax and taxing theory that Moore confirms does not actually exist as law or valid constitutional taxing theory. The Constitution does not authorize a non-apportioned direct tax on income that is to be enforced against the individuals earning the income. It authorizes only the indirect taxation of the specific federally taxable activities and transactions, taxable by impost, duty, or excise, which the government has authorized. The government never identified any such taxable activities or transactions that were allegedly conducted by the defendant to properly establish the taxability of his evidenced earnings. The court that allowed the trial and jury conviction and imposed sentence and ordered restitution be paid did so under an erroneous claim to a non-existent constitutional foundation and authority to tax directly and without limitation. Under the authorities above, the conviction and all instruments derived from it are void. Defects in subject matter jurisdiction require correction at any and every stage of the proceedings. Cotton Supra. So acting without subject matter jurisdiction to enforce a direct tax against individuals, all the civil claims and all the criminal judgments are void for lack of subject matter jurisdiction granted by the Constitution. That's the bottom line here. For 60 years, the courts have been acting without subject matter jurisdiction. It's the highest order of crime a court can commit. The highest order of crime a court can commit is to conduct trials and put people in prison for a pretend law that doesn't exist, or a pretend tax. You're being enslaved by judicial legislation and corrupt judges. Corrupt judges. This case presents questions of national importance that the 10th Circuit is entrenching through unpublished decisions. Scope of more in criminal tax prosecutions. Thousands of 7201 and 7206 prosecutions are brought annually under the erroneous direct tax theory framework, premised on the erroneous theory that the 16th Amendment authorizes a direct, non-apportioned income tax on all individual persons and their earnings. Moore directly contradicts that theory. The question of whether Moore's characterization of income taxes as indirect Article I taxation affects the constitutional validity of this prosecution and of all such prosecutions, and what the government must identify to establish the first element of Section 7201 under the correct indirect constitutional taxation framework. These questions have enormous national importance, affecting all pending and future criminal tax cases in every district and circuit court in the country, and the civil cases too, I would add. B, the trial record demonstrates why national guidance is urgent. The trial record in this case demonstrates the enormous, erroneous constitutional consequences of leaving the indirect, direct income tax question unaddressed and unresolved in this and other tax cases, when it was properly resolved under Moore, but remains unapplied in the circuit courts, because the circuit courts are refusing to apply the doctrine of stare decisis and implement the decisions taken by the Supreme Court in Moore within any tax ruling that they make. Same thing's happening in the tax courts. The circuit court's direct tax methodology, treating all gross income as directly taxable without identifying any specific taxable activity or transaction subject to federal taxation by impost duty or excise, is used not only at prosecution, but at sentencing to calculate tax loss, at the IRS to make civil assessments, and in collection proceedings to enforce restitution. At every stage, the direct tax error produces incorrect results that a constitutionally correct indirect taxation methodology would not produce if it were properly applied. The $10,000 fine being treated as a restitution order calculated on the erroneous direct tax methodology, locked in by a circuit court wearing blinders, and ultimately extended in this case through that fine as a direct tax with accruing interest, illustrates exactly why this court's guidance is needed. I hear the commercial break coming up. I'll be back in 5 with more. Okay, this is Thomas Fried on the Liberty Works Radio Network. Let's just get right back into this and continue with the reading. Where are we here? C, the 10th and 4th Circuit Courts are entrenching error through unpublished decisions. The 10th Circuit has now decided at least 2 cases, Walcott and Cromar, and the 4th Circuit in this instant case have all rejected Moore-based challenges through unpublished authority without engaging the Collins-Moore direct-indirect tax conflicts. The government will cite these decisions against every future criminal tax defendant in the circuit who raises a Moore-based challenge to jurisdiction. The constitutional question is being suppressed through accumulated unpublished authority rather than resolved through proper deliberative focused review by the courts. That is precisely the kind of circuit-level error this court's certiorari jurisdiction exists to correct. D, the quorum nobis and procedural default questions have national significance. The Fourth Circuit's procedural summary affirmation of the judgment without review or analysis in this case raises again the unresolved question of national importance. Whether a supervening Supreme Court decision that clarifies constitutional law applicable to a completed criminal conviction constitutes sufficient cause to overcome defective trial proceedings where the petitioner has exhausted all other possible remedy. This court has not addressed this question. Resolution of it would provide needed guidance to lower courts nationwide on the proper scope of judicial relief following the Supreme Court's intervention by supervening constitutional authority as stated in Moore or laid out. 7, the GVR alternative. Even without full merits review, a GVR is appropriate. The Fourth Circuit affirmed without, 1, addressing whether Moore abrogated the direct tax theory upon which the assessment of tax in the criminal prosecution of the defendant was premised and predicated, nor did it address the erroneous direct tax precedents of the various circuit courts on the constitutional point upon which the prosecution was based, i.e., as an unlimited and unavoidable direct tax on income under the 16th Amendment. 2, engaging the direct-indirect, the Moore-Collins, tax conflict that the full court declined to examine en banc. 3, the direct tax premised fine restitution methodology. And 4, engaging Moore's indirect tax characterization consequences for Section 7201 prosecutions. A GVR directs the Fourth Circuit to engage these questions on a complete record without requiring this court to resolve them here. The court issues GVR orders routinely when a lower court affirms without adequately considering supervening Supreme Court authority. That is precisely the case here. A GVR is an order from the Supreme Court to vacate and remand back to the lower court for further proceedings consistent with whatever holding the Supreme Court lays out. Okay, conclusion. Without a fully granted subject matter jurisdiction of the trial court over the specific criminal charges laid against the defendant, as argued, i.e. a direct non-apportioned tax, the district court may not proceed with trial or conviction and judgment on that erroneous and unconstitutional basis. The required subject matter jurisdiction was never properly and fully established or identified and disclosed on the record of the action in the trial court. The record is bereft of a constitutional power to tax that was allegedly relied upon to charge the defendant with tax evasion. The defect must be corrected, the defect in jurisdiction. Cotton Supra. The question and judgment was therefore secured, the conviction and judgment were therefore secured against defendant by what can now clearly be seen to be constitutional error. Because the federal courts do not possess the specific subject matter jurisdiction and necessary and required to act with respect to any alleged charged failure of the defendant to pay a non-apportioned direct tax, which the Constitution and the Supreme Court in Moore says does not constitutionally exist as a granted power to tax, and which therefore cannot be operationally imposed, assessed, collected, or enforced in or through the federal courts. They're enforcing a tax and taxing power, direct, unlimited, on individuals, and is never granted, not by the Constitution, not by the 16th Amendment. The courts lack subject matter jurisdiction to enforce these claims that you owe tax because you earned money. They have to identify the impost, duty, or excise that applies to the earnings, and there is none. You're not foreign, you're not doing interstate transport, you're not importing or exporting, you're not a corporation, you're not earning under license. And those aren't like licenses to be an electrician, a plumber, an attorney, or a doctor, or a pharmacist. Those are ATF licenses. Nobody owes, it's all a fraud. It's the second plank of the Communist Manifesto. Enslave the people and force them to service the Politburo, which will rob the rich and buy votes by passing it out to the poor. Until somebody points out that's unconstitutional. The conviction of the defendant and the judgment rendered by the district court was therefore, wrongful, constitutionally erroneous, and was rendered by a court that fatally lacked the subject matter jurisdiction to entertain the action as presented and argued by the plaintiff United States under the inapplicable and misapplied statutes relied upon, which cannot be used in the U.S. courts to enforce direct taxation against individuals. Quote, a court may not render a judgment which transcends the limits of its authority, and a judgment is void if it is beyond the powers granted to the court by the law of its organization, even where the court has jurisdiction over the parties and the subject matter. Thus, if a court is authorized by statute to entertain jurisdiction in a particular case only, like ATF, and undertakes to exercise the jurisdiction conferred in a case to which the statute has no application, like income tax under Section 1, the judgment rendered is void. The lack of statutory authority to make particular order or a judgment is akin to lack of subject matter jurisdiction and is subject to collateral attack. 46 Amjur 2D Judgments, Section 25, pages 388, 389. Okay, the wrongful and erroneous conviction of the defendant must be overturned because the judgment under which it was rendered is void ab initio, because there is no subject matter jurisdiction of the federal courts that can lawfully be taken by them to allow them to enforce a non-apportioned direct tax on income against an individual defendant. That's Constitution, Article 1, Section 8, Clause 1, Article 1, Section 9, Clause 4, and Moore Supra, 2024. The statutory, quote, the statutory and especially constitutional elements of jurisdiction are an essential ingredient of separation and equilibration of powers, restraining the courts from acting at certain times and even restraining them from acting permanently regarding certain subjects. See United States v. Richardson, Schlesinger v. Reservists to stop the war. Continuing, for a court to pronounce upon the meaning or the constitutionality of a state or federal law when it has no jurisdiction to do so is by very definition for a court to act ultra vires. Steel Company, aka Chicago Steel and Pickling Company v. Citizens for a Better Environment, 1998. The enforcement against individuals of an unlimited, non-apportioned, unavoidable direct tax on their person or their income is constitutionally prohibited. More supra. And always has been. Bruchaber, Stanton, Stewart machine. The conviction of the defendant is therefore void and must be overturned and the judgment vacated. Prayer for relief. For the foregoing reasons, petitioner respectfully prays this court grant the petition for writ of certiorari, vacate the judgment of the United States Court of Appeals for the Fourth Circuit, and remand for further proceedings consistent with the constitutional principles established in Moore, Bruchaber, Stanton v. Baltic Mining, Flint v. Stone Tracy, Helvering v. Taylor, Russell v. United States, and United States v. Cooper Corps. In the alternative, petitioner requests that this court consolidate this case with United States v. Cromar, number 26-6931 in the Supreme Court, and United States v. Walcott, number 25-1024, 10th Circuit, or any other pending case presenting the same or related constitutional questions about the effect of Moore v. United States on criminal income tax prosecutions premised on the erroneous, non-apportioned direct taxation theory. In the further alternative, petitioner requests that this court issue a GVR order granting certiorari, vacating the Fourth Circuit's judgment, and remanding for reconsideration, given that 1, Moore v. United States irreconcilably contradicts the direct taxation and unavoidable direct tax that was assessed by the IRS and upon which the prosecution was entirely premised. 2, the Fourth Circuit affirmed without addressing the obvious conflict therein, reflected in the trial record. And 3, the full Fourth Circuit declined to be polled on the constitutional question, confirming that this Supreme Court is the only forum that can resolve the obvious constitutional conflict and violations that currently exist in today's income tax enforcement system. Okay, so there you go. That's what we're sending up to the court. We think it's entirely reasonable. It points out the reasons why this Supreme Court has to engage in one of these domestic tax cases and set the record straight. The lower courts are insisting on locking American citizens up in prison because they allegedly didn't turn over money to the government because they worked. And it's not really a tax system, it's a slave system. You work, you owe. You work, you owe. It's not dependent on a federally taxable transaction or activity anymore. It's the 16th Amendment. And it's all been a lie. It's all been a lie. It's not a tax system at all. Not one penny goes in the Treasury. All the money taken from your paycheck, all the money sent in on a check on April 15th with your tax return is routed directly to the Federal Reserve Bank to collateralize the $39 trillion in debt being run up by an idiotic Congress. Doesn't care. Because they live like kings on the backs of your labor, which is being robbed outside the Constitution under the guise and pretense of taxation, which is really nothing but a peonage debt service system to service the unconstitutional debt owed to the Federal Reserve Bank, collateralizing the $39 trillion. Okay, I hear the end of the show coming up. This is Thomas Freed on the Liberty Works Radio Network. Find your way over to taxfreedom.com. Get informed. We'll be back next week with more. Thank you too. Yep. Bye bye. Yeah, image sharing. Turn off the image.